Oui, merci beaucoup, Monsieur le Président, et merci à Ministre Wilson Raybould et Ministre Philpott pour votre présence et aussi pour votre présentation aujourd'hui. I'd also like to thank you very much for your thoughtful comments and work on this very difficult issue. And I know that us as parliamentarians have heard from many Canadians on all sides of this difficult issue, and we want to do our very best to make sure that we've got a law that Canadians have confidence in, and that will see us move forward on this important decision from the Supreme Court of Canada. So thank you for your thoughtfulness and your assistance in that regard. I'd like to begin by asking a question regarding Section 7 of the Charter of Rights, which that argument is basically that, and we heard it in Carter, that some would be forced to choose between ending life prematurely by committing suicide or continuing to suffer until natural death once they lose capacity to do it themselves or capacity to consent to actually receiving medical assistance in dying. I'm wondering, I'd like to hear your thought on whether or not this Section 7 problem still exists with the lack of advance directives in the current bill.
Thank you for the question, and as we spoke about earlier, we sought to provide explanations in terms of what we included in the legislation and what we didn't include in the legislation, as well as looking at charter considerations around reasonable foreseeability, around advance directives and other issues. It is my view that and that we are going to further study these issues, that this proposed piece of legislation directly responds to the factual circumstances with respect to the Carter decision, that the object of this bill is to provide a peaceful passage to death. We recognize that there are other considerations, other views, and it is for those reasons and reasons that Minister Philpott indicated that we need to do further study to look at advance directives. We need to understand the risks and the benefits that come from advance directives in terms of the ability to make informed consent. But this proposed piece of legislation is about approaching the end of life and providing the vehicle and the mechanisms to enable people to have that peaceful passage.
And can I just add one
Please.
more thing? I would just, with all respect for the decision, I think it's most unfortunate if someone's in a situation where there really are only two choices, and one is to continue in suffering and a second is to seek assistance in dying. In fact, as much as possible, while recognizing, suffering, there will always be suffering in life. I think as we also need to find a way of making sure that there are provisions to alleviate suffering that may not include assistance in dying. And I think you will be tired of hearing me talking about this, but palliation, not in the sense of simply palliation at the end of life, but palliation is a term that needs to be applied whether people are approaching the end of life or not, and that we must find a way to do a better job so that people don't find themselves in a situation where their only choice is to either end their life or to continue to exist in suffering, and I believe we can do much better on that.
Thank you. Moving on to the reasonably foreseeable death, mention of that terminology in the bill. So basically that would be for someone who perhaps does not have a terminal illness, but their death is reasonably foreseeable on their current trajectory. Can you help me understand how a medical practitioner would be able to know if that person qualifies under the current bill? And is there any concern that if, for example, a lawyer was going to give advice to a medical practitioner regarding the current state of the bill, they may be very reluctant to say that it's okay, that you're on safe ground here. And my worry would be that you would see a lack of access because there may be medical practitioners unclear on the state of the law without actually specifying more clearly what reasonably foreseeable means. Could you comment on that, please?
So I'll comment on that, and I know that you will have other witnesses who will be able to ask about this as well. Certainly I can speak for the medical practitioners that I've talked to, including medical associations who represent large bodies of physicians, for instance, who have actually responded very positively to the concept of reasonable foreseeability, have felt that it's actually a good choice of terms. It's something that practitioners are, for the most part, comfortable with. We really had, three choices. We could have said nothing about the proximity of death. We could have specified a specific amount of time, 6 months or 12 months. But in fact, the concept of reasonable foreseeability is a concept that respects the professional judgment of a healthcare provider. It speaks to the fact that I'm just having a little glance at some of my notes when I spoke to representatives of Canadian Medical Association, who felt that one of the things that they liked about it was the fact that we can't cover all eventualities. It's very difficult in legislation to speak to all of those individual cases that might be there, and that in fact it was, as Minister Wilson-Raybould talked about, a way of defining just how grievous a condition is, so that it would make sure that it didn't include, for instance, a benign or a episodic type of condition, but it was a condition that was on a trajectory toward death. So we've had, as I say, very positive responses to that. Have not had any requests from medical associations that for some reason be removed, but it was felt to actually be very respectful.
Time for a
really quick.
Okay. With regard to paragraph 127 of Carter in Canada, it expressly provides that a patient not be required to undertake treatments not acceptable to that individual. In the bill, irremediable uses the term incurable as one of the ways to define it. But it doesn't go on there then to say that the patient not be required to undertake treatment not acceptable to the individual. I'm wondering why that's not in the bill, and if there was thought given to that.
There was thought given to that, and incurable has the same connotations as irremediable. In that same section, in subsection C, it does refer to the enduring physical and psychological suffering that is intolerable to them and cannot be relieved under the conditions that they consider acceptable. I think that speaks to the point that you've raised. So it's contained therein.